Hello, my name is Matthew Talbot, and I'm an elder law attorney in Walnut Creek, California, and I wanted to talk to you today about probate. I get a lot of questions about probate and the probate process, and so we want to put some videos together to help answer some of these questions and help people better understand what the probate process looks like. Now, the first and one of the most important things in the probate process is determining who's going to be in charge of the estate. There are a lot of fights and a lot of litigations over this, and people who don't understand what's happening can sometimes be at a disadvantage. So the first thing to determine is whether or not there's a will. Because if there's a will, that will most often name a particular person. That person's called an executor, and they have significant priority to manage the estate. If someone else wants to be appointed in lieu of that executor, they have to prove that the executor would be unfit for some reason, and that's extremely rare. So usually if there's a will, the court goes along with the named executor because it's a reflection of the intent of the testator. That's what the person who signed the will, that's their name, the testator. Larger issues arise when there's no will. And in that circumstance, there's a lack of clarity regarding the intent of the testator. What did this person want? Did he or she want their son or their daughter or their brother or their sister to do it? And sometimes you end up with these very nasty litigations between very close or close-seeming family members over the issue of who should be in charge of the estate. In that instance, they're not called an executor, they're called an administrator. And so the priority there is a lot murkier. There is a code section that lists out priority amongst family members. So for example, a child would have greater priority over a cousin and things along those lines. But it inevitably boils down to a lot of finger pointing, allegations, and sometimes very nasty allegations are made to try to keep someone from being appointed as administrator. So what I was hoping to focus on here is that you have an executor if someone is named under a will, but if there's no will, then sometimes multiple people have petitioned or will petition to be appointed as administrator, and a larger fight can ensue over who should be in charge of the estate. This doesn't relate to how assets are going to be managed. This doesn't relate to who's going to receive the assets at the end of the day. It merely relates to who should be in charge and sign on the dotted line. So if you have any other questions about being an administrator or being an executor or a loved one who's passed, don't hesitate to contact me. I'm here to help.